Now, doing business in India, many would say, is no cakewalk. We have myriad laws, we have so many regulations. So, to address those issues, the Jan Vishwas Bill has been brought in. This bill aims to decriminalise several kinds of infractions that would have previously landed a business owner behind bars even, because that's the kind of criminality that's associated with these laws or breaking these laws. So considering this, let's give you an example. A retail chain with stores in multiple cities across 2 states would have to comply with a staggering 3,000 different aspects of the law. Flouting of around 40% of these provisions could actually land an individual behind bars. Which is why we're asking, with the latest reforms that are being sought to be brought in with the Jan Vishwas Bill, has the Indian government earned the Vishwas of business owners? Is it going to ease business? And will these reforms accelerate entrepreneurship in India? Will it create jobs in the process? Will such reforms have a tangible effect on Indian growth? Let's find out. Rishi Agrawal has definite views about this. Rishi, of course, co-founder and CEO of Teamlease, is joining us along with Sanjay Hegde, who's a senior advocate at the Supreme Court. Gentlemen, both, thank you very much for making the time to be with us on India Tonight. Rishi Agrawal, coming to you first. I know you believe that our current business laws are inherently hostile and the need is to decriminalize and help ease do business in India. Do you think the Jan Vishwas Bill that decriminalizes as many as 183 minor offences under 42 union acts? They pertain to forests, they pertain to drugs and cosmetics, to food safety, to money laundering. Do you think this bill can achieve this need to ease doing business in India and trust our entrepreneurs more?
Well, thank you for having me on the show. As they say, well begun is half done. Will this move the needle significantly in its current avatar? The answer is no, because there are 26,134 items in Indian laws which can put an entrepreneur behind bars, among the 69,233 unique compliances. So among them, the bill moves the needle on 180 plus items. It's a small start, but the bill certainly lays the framework for examining criminality and jail term as a vehicle, as a lever of control that the government has utilized in the past. Most of these laws are colonial in nature. They were written at a time when India had just become independent and there was hardly any contribution of the private sector in job creation and economic development. In the last 75 years, the country has come a long way. The priorities have changed, the challenges have changed, the vehicles of growth have changed, and these laws have probably frozen in time. They've stayed frozen for a long time, and time has come to reform them.
Well begun is half done is what Mr. Agrawal is saying. Sanjay Hegde, what do you say? The Jan Vishwas Bill would change some leading acts. We're talking about acts like the Merchant Shipping Act of 1958, the Environment Protection Act of 1986, also the 1981 Law of Air Prevention and Control of Pollution, the National Housing Banking Act of 1987, and of course the Prevention of Money Laundering of 2002. Would you agree that some of the maximum criminal cases before the courts were concentrated in these laws, and reducing some of the fines imposed under the provisions of these laws would involve these lengthy court proceedings by converting them to penalties that would of course go without judicial intervention? Do you think this is going to free up the judicial system a little bit and broadly help the business ecosystem of the country?
Well, it would free up the judicial system to the extent that, much time is spent on prosecuting these and defending these ones, especially when there are big companies involved, there are big lawyers involved, and then there are bigger speeches involved. To that extent, yes, a certain amount of the court's time would be saved. But at the same point of time, we do not really have so many prosecutions reaching a successful culmination. Yes, the Damocles sword of imprisonment is always there, and it will be there on some compliance officer or occasionally the management, because ultimately, as the saying in corporate law goes, for a corporation hath not a body to be burnt or a soul to be damned. You have to catch hold of some particular person who was responsible for the compliance, and criminal prosecutions need to be given the full play before you come to any conclusion whether somebody should be jailed or not. So to that extent, the government must be commended. well begun, half done, half not done, whatever. But at the same point of time, you have seen that without these compliances, there's a tendency to resort to several shortcuts. The pharma industry, for instance, its recent products all over Africa, Sri Lanka, and whatnot have not brought us too much credit. How do you ensure credibility for Indian industry as a whole and for specific units of that industry in specific places?
Yes.
Sri Lanka has actually said that no medicines from one particular state in India.
Correct.
So therefore, even if you take away the threat of imprisonment,
Yes,
you must make any offender, corporate or otherwise, pay up heavily in penalties and disgorge any profits that the company may have earned in the process.
right. So there have to be checks and balances. It's not like decriminalizing and non-imprisonment means the lack of penalties. Rishi Agrawal, weigh in on this. There is this ongoing debate that Sir is referring to, that the changes to the Act that governs the manufacturing, the storage, the sale of medicines in India through the Jan Vishwas Bill may allow some drug makers to get off lightly if they are charged with making substandard medicines. Under the provisions now of this bill, there will be compounding where you pay a fine instead of getting imprisoned, at least for some of these offences. You don't see that as a possible deterrent, or do you think it's going to work?
So, Vikram, I'm going to take a larger view here. There are 1,536 different acts and rules that govern doing business in India. Embedded in them are about 26,134 items that can send an entrepreneur to jail. You examine some of these, at least 35 to 40% of them are extremely trivial. Failing to keep the whitewash record of an inner wall of a toilet, sending an entrepreneur to a 3 years imprisonment, failing to create a canteen committee, renew it every 2 years, sending them to prison. A lot of these laws were written with deep distrust, entrenched hostility, and imprisonment as a lever to send an entrepreneur to jail. Today, things have changed. The 21st century Indian entrepreneur needs to be a little more liberated than they have been in the past. Nobody has made the case that compliances should not be there or imprisonment clauses should not be there, but we need to differentiate between areas where theft has been committed, exploitation has been committed, damage to environment has been done, among others, and trivial procedural lapses and non-compliances, which has been used by the Inspector Raj, which has outlived its welcome in the 21st century now.
More about rationalization of these laws. Sanjay Hegde, we've also been trying for a while now, since 2019 at least, to overhaul our labor laws, to converge just under 30 different acts and putting them all in 4 different codes. That has been an uphill task as well. How important is that process now to be put in fast forward mode? What will it achieve, you think, by way of removing the criminal element from our labor laws?
Well, it's the same thing that when you remove the criminal elements, you may possibly be incentivizing lack of compliance. Many of these criminal charges happen when workers' PFs are not deposited, for instance. It is money which was owing to the worker, and then a finance manager says, okay, just let me use that money for a few months, and then that money never comes back. So it's the same thing, that if you take away imprisonment, nevertheless, you must have a strong prosecutorial machinery, which, even when it compounds these offenses, compounds it in a manner that the deterrence is achieved, that there is, in that old slogan, minimum government, maximum governance.
How easy that is going to be is an important bit to debate, but of course, one part of that debate is the importance of a universal enterprise number. That kind of reform applying to businesses, I'd imagine it works just like a DigiLocker does, at least it would hope to, where you can put all your government licenses and registrations, permissions, consent orders, all the statutory certificates of all kinds under that. How do you think that is going to ease up doing business for entrepreneurs, Rishi?
So, Today, there are about 23 different identities of an enterprise.
Yes.
You have a different PF number, ESI number, professional tax number, labor welfare fund number, GST number, PAN number, TAN number, and I can rattle off another 10, 15 of these identities. There is no consolidated view of the risk that an enterprise poses to the country or to employees and other stakeholders. We don't have a consolidated view of risk. We have no idea which of these employers have demonstrated good behavior, which ones have failed to demonstrate good behavior. We can't prioritize our inspections based on their past risk behavior. Now imagine banks giving credit today without having a credit rating for an individual. We would live in a world full of disaster where banks would not know whom they have lent and whether to expect that money back. That's the same situation we need to create with digital technologies for entrepreneurs. Today, we need a mechanism where there is a universal enterprise number, a unique number, against which the compliance profile, the risk profile of an organization can be established. Against that risk identity, you can decide how many times can they be inspected, who should inspect, whether they should be given certain amount of leeway, how frequently they should be inspected based on their risk level. All of these are important items. The second thing here is 1991 saw the first wave of reforms where the country got rid of the license Raj. 30 years later, in 2023, we still have Inspector Raj live and kicking. An inspector can show up at any point in time in any company, ask for any documentation. The need for presenceless, faceless, and cashless ecosystem is stronger than ever. We need to make the inspectors accountable. Just like we need to make an entrepreneur accountable, we need to make an inspector accountable. And until we create this presencelessness and facelessness to our compliance system, where there is a clear digital record and a footprint of a company's regulatory compliance in the past, some of these problems are not going to go away. They are going to persist, and they are going to shackle our entrepreneurs from creating more and more jobs in the economy.
Well, the argument is being made for building trust and faith in our entrepreneurs to kind of follow the laws, ensure compliance. But, of course, there are inherent risks in that, as Sanjay Hegde is pointing out. How we mitigate the risks in times to come with the kind of laws that we amend, that we create, that is going to be an important ask and an important place for the economy to grow as well. And we'll keep tracking that. Rishi Agrawal, Sanjay Hegde, many thanks for joining us with your perspectives on this edition of India Tonight.